Registrar, after it, did you understand count 1 I read to you? Defendant, I do, yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asking, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 that I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agabi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provide us, 1, the defendant to be tried on a charge or an information shall be A, brought before the court unfettered unless the court sees cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B, called upon to plead instantly unless where the person is entitled to service of the information, he objects to the non-service, and where the court finds that he has not been duly served. 3, the court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional rights to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999, as amended, provide every person, I quote, every person charged with criminal offense shall be entitled to be given adequate time and facility for the preparation of his defense. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the state, citation supplied. As part of the package of rights available to a person facing criminal charge, He is entitled to all the facilities and enough time for purpose of preparing his defense. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat JSC in Okoye and COP, citation supply, where my Lord held, and I quote, "The moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense. The court must accede to his request and the prosecution has to comply. The facilities that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statement of the witnesses interviewed by the police in the course of their investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward for to testify, unquote. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following date, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel, who he had earlier disengaged, to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denying adequate facilities to prepare for his defense. He had enough time to prepare. Had been represented by senior advocates such as Kanu Agabi SAN, Onyeshi Impeazu SAN, Emeka Ikpabas SAN, Paul Urokoro SAN, How do not get SAN, among others, before they were suddenly disengaged. And the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no water in the light of the facts and circumstances in this case. Consequently, this issue is resolved against the defendants. On the issue of extraordinary renditions, there are instances where a person commits offense against a country while residing in another country or flee the country soon after committing the same crime. In such instances, the country against which the offense is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a legal process in which a state renders a person accused of committing a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Enubuwa citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state, or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal fugitive flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have been tried and convicted but escape custody by fleeing the country, and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable persons from a country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refer to its.
Hi guys, this is live in Abuja, in the Federal High Court. Justice OMOTOSHO giving judgment on Mazi Nnamdi Kanu case today. Everywhere is tense. As we promised, we keep on monitoring the situation and we bring it to you live. So this is live, so please keep monitoring, the situation, because the court is tense as Justice OMOTOSHO give judgment. We'll be right back. Please stay tuned.
In this court, so as to